You don't have to be super amicable to do collaborative divorce. It can be a little bit contentious and still have a successful collaborative divorce. Hi, my name is Jennie Bouska. I am a certified divorce financial analyst, and I am here with attorneys Teena Johnson and Wendy Zicht, and I'm going to ask them some questions about collaborative law and our divorce process. So, Wendy, first question is to you. What is collaborative law?
Collaborative law is a form of out-of-court dispute resolution. It can apply to really any kind of dispute. We hear about it more probably in divorce, but it could apply to employment law, personal injury law, really any dispute you can think of, estates, will contests, those kinds of things. And I say out of court because it is a form of mediation where the parties decide that they want to resolve their case out of court and they hire lawyers to help them work through the issues out of court, keep as much information out of court as possible. And the attorneys that they hire preferably are trained in the mediation model, and they use their mediation skills to assist the clients to resolve whatever the issues are. So that's collaborative law in a nutshell.
And there's more to it
Oh, there's
beyond
much
that.
more. There's much more to it. It's much more defined than that. What another important difference is that in a collaborative divorce, not only must both parties have an attorney to assist them, but the attorneys are cooperative with one another. We work as a team to help the couple reach a resolution. And so we have a dual role, so to speak. We represent our client. We have meetings with our clients individually to discuss their concerns, but we also meet with the other lawyer and their client all in the same room and work on resolving whatever the conflicts are together.
Nice. And the key words I heard you say multiple times was out of court.
Correct. Right. Now, when you reach an agreement, if you want a divorce, you have to enter a divorce order, which a judge has to sign on. So eventually you will be doing that. But that is the court's only involvement in the process is to approve your settlement. You don't have court hearings. You don't have to file documents with the court raising whatever the issues are and have a judge decide them because you're putting yourself as client with your attorney in the position of the judge. So you become your own judge of the issues in your case along with your spouse.
Nice. Okay, great. If a client were, and this is to both Teena and Wendy, if a client or when a client comes to you and they are at the very, very beginning and they're just like in a consult, what do I do? Or how do I even start this process? What are their options? Can you speak to what their options are for divorce?
I'll begin with that and then I'll turn it over to Teena. One of my first questions to a potential client is, are all of you are you and your spouse in agreement on all issues? And I explain you have to agree upon how you're going to divide your assets, which are tangible and intangible. Do you have a house? Do you have pensions? Do you have bank accounts, cars, boats, trailers? Whatever you have to figure out who's going to keep what. That's one issue. The other is your parenting, and probably that's the most important issue if you have children. What are each spouse's parenting time going to be? And then you have to decide how you're going to divide up any debts. You have to decide what you're going to do with your pets. That's a common issue, just like with your children. Is there any problem with one spouse needing to get more income and needing training so that we need spousal support or what we call alimony? And so, if any of those issues you're unable to talk with your spouse about, or you don't have an agreement on, and after talking to them, you have what I call a contested case. That means you need help. And your choice at that point, your fork in the road, is to either take it to court or to go through some out of court dispute resolution, such as mediation or collaborative law as an alternate process to help resolve those issues. If everything is agreed, however, you've worked it all out, you just want to get it legal with the court, then you have the option of doing a kitchen table divorce. That's a common term that we all use. And they happen a lot. A lot of those cases are done by parties without attorneys, or they use a legal drafting service and we don't see them in our offices. If there's real estate or there's complicated pension divisions, those are the cases that usually we see. The parties have worked it out, but they need attorneys to draft the documents for them.
So that's the kitchen table
That's
divorce.
the kitchen table.
And and
And
and contested doesn't mean we're going to court. It just means we don't agree on everything.
right, they have, it's their, I look at it as a fork in the road. They can decide do they want to go to court and probably create more issues than they thought that they had to begin with, or they can take whatever issues they have and resolve them out of court. And they can do that through a typical mediation or a collaborative law process without any judge involvement.
Got it. So Tina, what's next step if it's a little bit more contested than kitchen table? What would be our next option?
Well, most of the people that I talk to are trying to stay out of having the judge decide it. They don't want to have a highly contested court case. So we're really looking at what do we do in between that. Sometimes we're looking at mediation. If clients are doing mediation, they wouldn't have attorneys in the room with them. They hopefully or may have consulting attorneys outside of mediation, but the mediator is not able to give them legal advice and is restricted in their ability to draft some of the documents. So the next step, if they're needing help with those things, might be a collaborative case. And in a collaborative case, I'm talking with the clients to try to figure out if this will work for them. One of the first things I ask them is, well, how is communication going with the other spouse? It doesn't have to be communication doesn't be going well, but I want to try to find out if clients if they are going to be comfortable talking in a room with the other spouse. So we talk about that. They'll need to be able to do that if they're doing mediation too. And it's just sort of discussion about how comfortable they feel with the collaborative process and whether that would be a good fit for them.
So that's collaborative. And then what comes after collaborative? If the client says, we're not talking to each other and I cannot be in the same room with this person, then what?
Well,
Well,
then
at that
more
point,
traditional litigation case
yeah,
most likely.
I agree. More traditional or litigation, or you might have what we call more of a settlement conference model mediation where the clients do hire lawyers to represent them and they hire a third party mediator, probably an experienced family law attorney or a retired judge to mediate their case. And they do all appear either on Zoom or at a mediator's office, but using a shuttle model, frequently called camps. So one camp would be one spouse and their attorney, and the other camp would be the other spouse and their attorney, and the mediator is the shuttle, essentially shuttling information back and forth and trying to force people into an agreement over a period of hours, sometimes a day, and sometimes follow-up sessions. But it is not an interest-based model. It is more a cost-benefit analysis model and trying to reach an agreement just to keep out of court, right? So with the goal of just resolving it, staying out of court, and what am I going to gain if I go to court versus what can I gain through this mediation, and taking into consideration the cost of the battle going to court and trying to avoid that. So it's a different mindset from a collaborative mediation model.
Jenny, I want to respond again to your question. Sometimes clients will say to me that they don't think they're going to be comfortable in a team setting, or they think that their spouse won't be able to do that. And so I talk a little bit more about how the collaborative process works and how it's a team process so that both of the clients, both of the spouses can feel supported and can feel like they can be present and in a team setting. So it wouldn't be like they have to talk just one-on-one with their spouse. They would have a team, including me, helping them to get ready for meetings, to get through meetings. And so sometimes the clients that I talk to realize that, well, given that, that might be a process that works for them. And that might help them get through a divorce without having to do the court and trial and all of that kind of system.
You don't have to be super amicable
No.
to do collaborative divorce. It can be a little bit contentious and still have a successful collaborative divorce.
Absolutely, because the professionals that are working in collaborative law have lots of conflict resolution training and experience. And so we help clients get through the process, even if it's not very amicable.
And I'll say my experience with the mediation that Wendy described, where it could be a day. I've been a part of those mediations, even as a CDFA, and I'm sure you two have done plenty of them. And I will say, at the end of those days, to watch clients make decisions out of exasperation, that is painful to watch. I mean, even if they're pleased with it, it's still just an exasperated yes or an exasperated I give, and it's going to be a difficult thing to be a part of, just as the CDFA in that case.
And I go
Go ahead.
ahead.
Nope.
I thought you were done, but I want you to finish your train of thought.
Nope. I was going to move on. So go ahead.
Okay. And I so agree with you, and I'm sure Teena does too, because we really try in our collaborative cases to stick to a timeline. We set our meetings, what that we call way meetings, with the attorneys present and you present, or perhaps a coach present, for no more than 2 hours for that reason, because we don't want people to make decisions because they're just tired and they're uncomfortable and they just want out of the room after so many hours. And we know after 2 hours, that can be exhausting. And so it's very purposeful, even though people may want to stay longer. We really hold to that time frame.
Wendy, you're absolutely right about that. We want clients to reach agreements that are going to last, that are going to be durable, that they're going to be comfortable with going forward.
So that takes us to the last thing that we've alluded to throughout this topic, which is court. So who wants to talk about what it's like when you go to court?
Well, I'll
Wendy.
chime in first and I'll let Teena. I'm sure we've had similar experiences. The court process really discourages any kind of early resolution, because once you file a case and you feel compelled to lay out allegations against your spouse and they respond, you create this relationship between the two of you that's different, of course, from the marital relationship, that is an adversarial relationship through the attorneys or through the court pleadings. And it's very hard to want to resolve things quickly when you're now having to respond to perhaps allegations regarding your parenting or your handling of finances. So when a court case is started and the parties can't agree upon who's going to move out of the house or who's going to have the children most of the time, the first step is a motion hearing in front of a judge for a judge to make that decision. And that's based upon the pleadings that both parties file and their story that they tell. And so rather than beginning the case with identifying what your conflict is, what steps we want to use to reach an agreement, and then setting an agenda for the next meeting to talk about those in a mediation model, you're completely in an adversarial model from the beginning. And most of these cases, 99.999% of them, are going to get to mediation, because by the time you work your way through the system and you pay your lawyers for that initial court hearing and then follow-up hearings and paying your attorneys to do depositions and other discovery methods to get information, you're going to want a mediation session because you can't afford trial, and you're going to resolve it at mediation. But that's 6 to 8 months into the case, where in a collaborative case, your very first meeting is a mediation session. So that's, to me, is a big difference and a big negative characteristic of how the adversarial model handles a couple divorcing versus a mediation model through the collaborative process.